Chapter 4. Indication of origin or ownership. Section 144. Indication of origin or ownership. This is a phrase that of late years has been the source of much perplexity, simply because not understood in its legal acceptation. The Supreme Court of the United States, in the President, Fock, of the Del. F. Hudson Canal Company v. Clark, repeated a proposition that as a rule has been frequently enunciated, and settled beyond question, viz. The office of a trademark is to point out distinctively the origin or ownership of the article to which it is affixed, or, in other words, to give notice who was the producer. Section 145. The difficulty is this: what does distinctively indicate such origin or ownership? That question can be intelligently answered only after the examination and collation of many adjudications. Each case necessarily depends to a great extent upon its own peculiar surroundings. What might indicate origin in one matter might not in another. Sometimes the name of a proprietor or of a place is required to clearly convey the indication. Again, any simple device may by association with a particular person or place convey all the information required. What impression does the mark of commerce leave upon the vision of the beholder? What associations are called up by the sound of a word? A purchaser usually instantly recognizes a symbol, and buys on its faith, just as one might purchase bonds of the United States upon the most superficial glance. He asks for a 10-40, a 5-20, or a 7-30. And does not think of keenly scrutinizing its various indicia of genuineness. Its origin is clearly indicated. He has not the slightest suspicion that the thing a broker sells to him has been simulated. One buys a barrel of flour or a fancy toilet article with the same apparent carelessness. The true test is confidence. The brand, or the mere name of the article, satisfies him. Good faith is the bond of commerce, and without it doubt and hesitation will fetter enterprise and restrain trade. Section 146. The words Congress Water were held by the New York Court of Appeals, in Congress and Empire Spring Company v. High Rock Congress Spring Co., to appropriately indicate both the origin and the ownership of the water flowing from Congress Spring, to which place the plaintiffs had the sole title. The defendant's counsel argued that the words, as applied to a natural element, were an inexplicit name, expressing no idea of property or origin, and that the said mark lacked the essential elements, being used to designate the article itself by its proper appellation, therefore not the subject of exclusive appropriation, that, in fact, it expressed no more than the name of the spring, like Avon Springs, Lebanon Springs, Sharon Springs, and Cheltenham Springs, being names of particular fountains, indicative only of the place whence they issue. It was also insisted that the doctrine of trademarks has never been applied, and is not applicable, in letter or in spirit, to the sale of spontaneous natural products of substantially the same nature, being appropriate only to artificial compounds, or products, originated by the science, or skill, or diligence of man, and that this water, not being the creation of man's skill or industry, but being the gift of nature to all, no one could bottle and name the elements, and claim exclusively the new appellation by which they have become known in the market. It was said by counsel that one might as well bottle the pure air of the mountain, and prevent another from selling the same air by the same name. A preliminary injunction having been dissolved at special term by Rosecrans, J., the plaintiff appealed to the general term, which affirmed the action of dissolution. James, J., in rendering the opinion of the court in Bank, said that he was not aware that the question of the application of the law of trademarks to names given to spontaneous or natural products had, prior to that time, ever come before the courts for adjudication, and that, in all the cases, the principle of the law is stated and restated, as applicable to protect the skill, industry, and enterprise of mechanics, manufacturers, and inventors, and hence only applicable to artificial products. He seems to have excluded from consideration the idea of commerce, which may deal in commodities with which the skilled industrial classes have nothing to do, and which, although natural products, as coal, marble, or animal deposits, like guano, have distinctive marks entitled to protection. The case went to the highest court. The true principle involved had by that time become clearly apparent. Section 147. The Court of Appeals considered these two questions. 1. Can the owner of a peculiar product of nature be protected in the exclusive use of a name belonging to it alone, and employed by him as his trademark in the sale thereof? 2. Does the name or trademark used in the case before us by the plaintiffs indicate the origin, ownership, or place of that product, and is it one in the exclusive use of which the plaintiffs should be protected? The court, by Folger, J., said, inter alia, that here is a particular article of which the owners of this spring possess the only source, and which can be had only from them. The violation and the wrong are the same whether the commodity is one which the hand has made, on which nature has put into the hand of man. Certainly so, if into the hand of but one man has it been put. It is a matter of property, and the profitable use of property. If one use the name of another for the purpose of securing to himself, in the disposition of property, advantages which belong to that other, the fraud is complete, and the remedy ought to be complete. By the application of capital, business sagacity, and enterprise, this spring and its products have become extensively known, and favorably received. When one wishes for the medicinal water which he has used before, he inquires for it by its specific name. And it is this name, the trademark of the plaintiffs, which is the short phrase between buyer and seller which indicates the wish to buy and the power to sell water from that origin, that place, of that ownership. This phrase, this device, is the trademark of the plaintiffs, and is of value to them, as thus designating the verity of its origin. They have the right to be protected in its exclusive use, for none other can use it with equal truth, and none other has equal right to employ it for the same purpose. Held. The words Congress water are, under the circumstances set forth, a valid trademark indicating origin, and also ownership. The judgment below was reversed, with costs, and a new trial ordered. Section 148. In Falkenberg v. Lucy, before all the justices of the Supreme Court of California, in 1868, the court said that the owner of a mark would be protected in its exclusive use, but only so far as it serves to indicate the origin, or ownership, of the goods to which it is affixed, to the exclusion of such symbols, figures, and combinations of words which may be interblended with it indicating the name, kind, or quality of the article. In this case, the plaintiffs claimed the entire label as their trademark, and asked to be protected in the use of it as a whole. The court said, only so much of their label as serves to indicate that they are the manufacturers or vendors of the washing powder can be considered as constituting the legitimate characteristics of a common law trademark. The symbol must tell its own story. It does not serve its intended and true purpose until associated with a certain person or article. In Philly v. Fassett, before the Supreme Court of Missouri, in Bank, in 1869, it was held that the words chartre oak, cast on cooking stoves, were sufficient to point out the true source and origin of the stoves, and were therefore possessed of the requisite characteristics of a trademark. In Fettridge v. Wells, in 1857, J. held that the words, the balm of thousand flowers, might suffice for this purpose, unless, of course, they were descriptive or fraudulent. Boardman v. The Meridian Britannico, in the Supreme Court of Connecticut, in 1868,8 fully recognizes and enunciates this doctrine. Section 149. As an instance of the disagreement of judicial minds as to what in contemplation of law constitutes indication of origin, we will cite Ferguson v. The Devil Mills, in the Common Pleas of Philadelphia, in 1868. The facts are briefly these: more than 30 years before, the complainants devised, and ever since used for certain goods, known as Silesias or bleached and dyed cotton twillings, a certain mark, which consists of a circular label with the letter K in the center, which letter is surrounded by plain lines and ornamental tracings, extending outward from the center, and having nothing on it except the printed letters No. At the top, and at the bottom of the same space the letters yards. By long use this mark had become identified with the said goods, and the goods came to be known in the markets of the world, and to the trade everywhere, by the said mark, and are known and called by the name of the case Silesias. The defendants manufactured and offered for sale goods similar in appearance, but greatly inferior in quality to the complainant's case Silesias, put up in wrappers similar to theirs, and a counterfeit of their label and mark. The defendants asserted that the use of the letter K and accompanying device, as printed by the complainants and pasted on their goods, did not constitute a trademark such as the law will protect. Allison, P.J., said, the device and letter K, which constitute the alleged trademark, have no name, words, signs, marks, by which in any possible manner or degree the origin or ownership of the Silesias manufactured by the complainants are indicated, or the place of sale or manufacture pointed out, to distinguish them as the goods manufactured or sold by the complainants. And, failing in this, it follows that this application for an injunction cannot be granted. And this will justify itself when it is remembered that these circular lines and spaces, and intervening ornamental tracings and letter K in the center, with elliptical cross lines upon its face, affords no protection to the public against imposition by the complainants from the sale of a spurious or inferior article of Silesia. They could flood the market with such inferior article, stamped with what they call their trademark, and the public would be wholly unable to ascertain who had manufactured and sold the goods. Protection is given only in consideration of the guarantee of the integrity of the manufacturer or merchant, certified by his trademark. When the device fails to accomplish this end, it is no trademark, and all claims founded thereon must be rejected. The simplest case of a trademark is the name and address of the claimant, and it is absolutely requisite that a device or symbol should perform the office of a fingerboard, should indicate the name and address of the manufacturer, to invest it with the attributes, and entitle it to the protection, of a trademark. The device of the complainants does not contain, within itself, a declaration to the public that Ferguson Brothers are the manufacturers of the Silesias stamped with their device. It points to any other person as clearly as to them, and therefore it is obvious that the Devil Mills, or Fales, Wharton, and Co., in imitating this device and placing it on an article of Silesias of their own manufacture and sale, have committed no legal wrong of which Ferguson Brothers have any right to complain. The morality of the use by them of the simulated label is another question, for simulated it is, beyond all doubt, so much like the original as to be scarcely distinguishable from it. Injunction refused. Section 150. This decision is sui generis. The course of reasoning of the learned judge does not commend itself to any calm, thoughtful intellect. With all due deference to the opinion of Judge Allison, criticism is imperatively demanded, for it is the emanation of a respectable tribunal, and cannot be silently acquiesced in without positive injury to the cause of justice. It has been quoted in more than one case by counsel driven to desperate shifts, and has been strenuously urged as an authority. He has said that the device of concentric circles enclosing the letter K does not in any possible manner or degree indicate origin or ownership. Why not? Because, said he, the place of sale or manufacture is not pointed out, and he intimated that the device, to be a valid trademark, should contain the name and address of the claimant. If so, how could a great number of symbols reported in adjudicated cases have been recognized as perfectly valid, when those symbols were no more expressive than that under discussion? As instances, consider the distinctive names and designations Excelsior, Climax, Empire, Charter Oak, which were deemed perfectly good trademarks for stoves. The word Excelsior, for soap, Ethiopian, for stockings, Cocoine, for hair oil, ICA, which the court virtually held might be a valid trademark. Section 151. Not one of these cases indicated the name, or even the address, of the manufacturer, or of the merchant. Yet they fully answered the legitimate purposes of a trademark. The judge said that the symbol in the Devil Mills case was no protection to the public against imposition by the complainants from the sale of a spurious article, for they could flood the market with an inferior article, and the public would be wholly unable to ascertain who had manufactured the goods. Now, a trademark to be worth anything must be recognized by the public, and must be associated with a particular person or firm, so that the purchaser instantly says in his own mind, that is the article I wish, I know it is genuine, because it bears the well-known mark of so-and-so. What is the logical deduction of the judge? The mark is not associated in the mind with anybody or any place. It has not the slightest intimation of origin. By looking at it, the public cannot possibly guess who made the goods, or where they were made, or who offered them for sale. It promises nothing. No faith is given to it, for it is absolutely meaningless. It is virtually a blank. Well, the public not recognizing the symbol as any man's manufacturing or commercial signature, and perceiving in it no guarantee of the integrity of the manufacturer or merchant, yet bestow upon it the most implicit confidence. Through their infatuation the market is flooded. We answer, if the public buy on the credit of the mark, that is the highest evidence of its validity. Knowing the currency of their mark, its owners strain every nerve to sustain its reputation. To send out spurious goods with its impress upon them, would be to kill the goose that lays the golden egg. We must conclude that His Honor erred. If its 30-year-old reputation had not made the symbol valuable, it would not have been counterfeited. Yet it was simulated by the defendants, so that their false token was not distinguishable from the genuine. What essential ingredients of a lawful trademark did it lack? None. Section 152. When there are several mints for coining money in one country, some distinctive letter or mark usually indicates at which one a piece was coined. In the United States the three branch mints at Charlotte, Dahlonega, and New Orleans have used the initials C, D, or 0, respectively. The principal mint at Philadelphia had no such mark. Yet the single letter, when found upon a coin of precious metal, was a sufficient indication of its precise origin. In South America, some of the mints have used monograms, or involutions of letters, one complex character indicating Lima, and another Potosi. The metal in one coin may be finer than that in another of the same nominal value. Preference can be awarded by means of the mark. It is just the same with any other commodity. Two articles may be of the same outward appearance, the same color, weight, size. The purchaser has no guide to assist his judgment, except the reputation of a certain manufacturer. He discovers his mark of authenticity and guarantee. It is enough. He buys. Section 153. The Muskeg Manufacturing Company v. Speer, before Dieu, J., in the Superior Court of the City of New York, in 1849, and already discussed, is a leading case. The plaintiff averred that the letters A California, relied upon as a valid trademark, were intended to denote as follows: I.C., a Muskeg Company, and A, first quality. These letters were affixed to a kind of cloth called tickings, which by much care and skill, and at great expense, the plaintiff had brought to such a state of perfection, that the best quality had obtained a high reputation throughout the country. The defendants denied the allegation of the meaning of the said letters, and averred that they referred altogether to the quality of the tickings, and they denied that the plaintiff's goods were known as the Asia tickings, without the addition of the name or place of manufacture, but that they were known as the Muskeg Asia tickings, in like manner as the defendant's goods were known as the Lowell Premium Asia tickings. The answer also averred that all manufacturers of tickings used letters to denote the different qualities, and that, in every case, the name of the maker or place of manufacture was added, to enable the public to distinguish between articles of similar quality made by different manufacturers. The answer further denied that the defendants had used these letters to enable them to sell their tickings as those manufactured by the plaintiff, or that their use had produced that result, and admitting that they had sold their goods as the genuine Asia tickings, it was always with the designation that they were Lowell, and not a Muskeg, tickings. The defendants, for 5 years before the action was brought, had used a label corresponding with that of the plaintiff in size, color, fancy border, position, general arrangement, and size of the letters, and also containing, in large capitals, the letters ACA. A preliminary injunction was granted, restraining the defendants, according to the prayer of the complaint, from using on their tickings any label such as that which they had used, or any label similar to the plaintiff's, or an imitation of it, or having thereon the letters ACA. This was a motion to dissolve or modify the injunction, which had been granted ex parte, on giving security. Section 154. The legal title of the plaintiff in the present case to the exclusive use of these significant letters, ACA, was denied. They were said to be but an indication of the quality of goods, and that they were used as all manufacturers use letters to denote the different qualities. If so, it is clear to any comprehension that they did not constitute a trademark. The question to be decided was whether they did merely denote quality, or whether they did not constitute the peculiar symbol that indicated origin. If the said letters, as used by the plaintiff, were merely an indication of the relative quality of its tickings, they must be expunged. As the plaintiff could not have acquired, by prior occupation, an exclusive right in the use of the words first quality, or superfine, it could not have acquired by similar means a right to an exclusive use of any letters, marks, or other signs, which are merely a substitute for the words, and intended to convey the same meaning. It is immaterial, said the judge, whether words, or letters, or figures, or any other signs are used, if the single fact which they are used to indicate or declare is a truth that other manufacturers or dealers have an equal right to express and communicate. The judge found, as a fact, that its letters of California were employed by the plaintiff to indicate quality, and for no other purpose. He said that it is doubtless true, as is stated in the complaint, and sworn in many of its affidavits, that the tickings of the plaintiff to which its ACA is attached, have for many years been known in the market as the ACA tickings, but this fact neither alters the meaning of the letters, nor takes from others the right to employ them. If the letters designate only the quality of the goods, and not their origin or ownership, the tickings of the defendants, if the best quality of those which they sell, are as truly ACA tickings as those of the plaintiff. The words, power loom are found upon the label of the plaintiff, yet it is not contended that I could restrain the defendants from using the same words as they have done upon their own. If there exists a distinction, I am unable to perceive it. The claim of an exclusive right rests in both cases upon the same grounds, it is valid in both, or in neither. The learned judge held that the conclusion was irresistible, that the three letters were used to designate the best quality of tickings, and for no other purpose. He therefore struck from the injunction the words or having thereon the letters ACA, but retained the rest. Section 155. What conclusions are deduced from this Muskeg case? Let us again glance at the facts. A preliminary injunction had been granted upon the ex parte application of the plaintiff. It had made out a prima facie right. Upon the coming in of the answer, which denied the plaintiff's allegation of an exclusive right to the letters ACA, it was moved to dissolve or modify the injunction. As to the imitation of the label in all its features, there could be no gainsaying. It was apparent. Testimony could not countervail the evidence of ocular demonstration. But the label was not a technical trademark. Perhaps the three letters were. It was so asserted on one side, and denied on the other. It was an equipoise. In such a case, an equitable remedy would, by the rules of equity, be withheld. Take the language of the judge in rendering his decision. I can give to the defendants, however, the benefit of the general rule, by so modifying the injunction as not to restrain them from using the letters ACA, until the legal right of the plaintiff shall have been established by the verdict of a jury in this suit, and I am satisfied that it is this course I should be bound to follow even were my opinion as to their legal right widely different from that which I have expressed. The court did not decide that the three letters could not be a lawful trademark. It decided that the case as presented did not establish the plaintiff's right. A jury must pass upon the disputed right. Section 156. This matter had a sequel in the Patent Office. In 1872, the Muskeg Manufacturing Company filed an application for registration of a trademark, consisting of the said three letters, a California. The label on which the letters are printed is substantially that before described, the same that has been used for 36 years. After a careful examination of authorities, the letters were recognized as containing in themselves the essential characteristics of the manufacturer's and merchant's symbol called a trademark, and the certificate of registration was duly issued. Section 157. In Stokes v. Landgraf, at a special term of the Supreme Court of New York, in 1853, Strong, J., clearly laid down the doctrine of the Muskeg case. In respect to words, marks, or devices, which do not denote the goods or property or particular place of business of a person, but only the nature, kind, or quality of the articles in which he deals, no property can be acquired. There is obviously no good reason why one person should have any better right to use them than another. They may be used by many different persons at the same time, in their brands, marks, or labels on their respective goods, with perfect truth and fairness. They signify nothing, when fairly interpreted, by which any dealer in a similar article could be defrauded. The plaintiff was a manufacturer of glass, at the village of Clyde, in the town of Galen, in the county of Wayne, state of New York. His complaint alleged that he was entitled to the exclusive use of the words Galen, Lake, Cylinder, Wayne, New York, which had long been used by his predecessors and himself to denote the qualities of glass made at his establishment, and to distinguish the same from that made by others. A temporary injunction was granted, which the defendants applied to have vacated. The question to be determined was whether the words so used by the plaintiff were embraced by the law of trademarks. Did they indicate origin or ownership, or merely denote quality? Section 158. In his complaint, the plaintiff alleged that the word Galen was used to denote the first quality, the word Lake to denote the second quality, the word Cylinder to denote the third quality, the word Wayne to denote the fourth quality, and the words New York to denote the fifth quality of glass manufactured at his works, and that the said marks or brands had ever been and still were used to denote and distinguish the respective qualities above mentioned. It was also alleged that the defendants have manufactured for sale large quantities of window glass, greatly inferior in quality and value to that manufactured by the plaintiff, and caused it to be put up in boxes or packages, and fraudulently caused the said boxes or packages to be branded or marked with the words mentioned, in imitation of the several brands or marks used by the plaintiff, and with intent to cause it to be believed by the purchasers, builders, and the public, that such glass was manufactured at the glass works belonging to the plaintiff, and to enable the defendants to sell the said glass as the manufacture of the plaintiff. The answer denied that the said words were used by the plaintiff to distinguish the glass manufactured by him from that manufactured by other persons, or at other manufactories, and insisted that they were used by both parties to distinguish the several qualities of their glass. They also denied any design to divest the plaintiff as trade, and that they made an inferior article. Section 159. The court held, that in regard to the words Cylinder, Lake, and New York, there was no propriety, or even plausibility, in the claim that they were used by the plaintiff, in part, to distinguish his glass, or glass of his manufacture, that they were not adapted to that end. Besides, the practice of manufacturers of glass, as above stated, and the appearance of the plaintiff's marks or brands in connection with it, showed that they were used to denote quality, and the plaintiff admitted that was, in part, his object. Some other of the words had not been used by the defendants. Injunction dissolved. This case was appealed to the General Term, in 1854, and the decision was affirmed. Section 160. Let us take another look at Stokes v. Landgraf. What principles governed the decision? Here are facts that will assist in the elucidation. The plaintiff's complaint was rather inartificial, to commence with. It admitted too much. The word quality was used in a loose sense. Did it mean merely to denote the different grades of a common article of manufacture? Was it not meant to be said that the words were employed only to distinguish the glass manufactured by the plaintiff from that manufactured by other persons, or at other manufactories? To say the least, the language was unhappy. Annexed to the answer are transcripts of the several marks or brands both of the plaintiff and defendants, from which it appears that in each of the plaintiff's marks or brands, in addition to one of the words above named, are his name, and the village where his manufactory is situated, with a representation of the size and number of feet of glass, as 5 Stokes, Clyde, Galen, 8 by 12, 50 feet, or Stokes, Clyde, Cylinder, 8 by 12, 50 feet, and c. And that each of the defendants' marks or brands, having either the words Galen, Lake, or Cylinder, has, in addition, the name Landgraf, with a representation of the size and quantity of glass, as Landgraf's Galen, 8 by 12, 50 feet, or Landgraf's Cylinder, 8 by 12, 50 feet, and c. The brand of the defendants having the name New York, is in this form, Cleveland, New York, with a representation of size and quality as above given. Each party used the name of the place of manufacture, Clyde, and Cleveland. The names in dispute were not so affixed as to be the salient points that would strike the purchaser's eye, arrest attention, and operate as a guarantee. No one would pin his faith to any one of the words by itself. The names had no blandishments to allure and captivate. They meant no more than would the numerals 1, 2, 3, and C. Indications of comparative quality. But the strongest objection is this: most of the words claimed are names of localities. No one can usurp geographical names which all in common have a right to use. But the rule as to the exclusive use of a name of locality must be taken with its limitations and qualifications. If the plaintiff had owned the whole village or spot whose name was borrowed, he might have a right to the name, as in the Congress Spring case, or if he had used a name which others in the same village had a right to use to denote a peculiar natural product, one not found in any other place, although that would not be, strictly speaking, a trademark, for it would lack the essential element of exclusive right. He would have rights which a court of equity would protect. The plaintiff's case did not make out his claim to any remedy. The words were not used as trademarks. It was therefore unnecessary to consider the question of priority. Section 161. Terms in common use to designate a trade or occupation, in connection with other words indicating that a particular class of merchandise of the same general description is specially dealt in, cannot be exclusively appropriated by anyone as a trademark. In Choinsky v. Cohen, Supreme Court of California, 1870, the plaintiff claimed the words antiquarian bookstore as his peculiar symbol. The court said that the case depended upon the effect of the word antiquarian, as used in connection with the words bookstore. As applied to a bookstore, it can have no other meaning or effect than to indicate to the public that the proprietor deals in a certain class of books, to wit, ancient books, or books pertaining to antiquity. Anyone reading the sign, antiquarian bookstore, over the door, would naturally expect to find there for sale either ancient books, or books treating on subjects connected with antiquity. It could not, by even a forced construction, be made to signify that the plaintiff's business had been long established, and was of ancient origin, for the complaint informs us that the business was established in 1863, and that it had the name of the antiquarian bookstore from the beginning. It was used precisely in the same sense that the words law bookstore, or medical bookstore, or divinity bookstore, would indicate that law, medical, or religious books were for sale. In all such cases, the words employed are but advertisements that certain goods are sold. Section 162. The case of R.W. English, appeal from the examiner, November 2, 1870, to the Commissioner of Patents, has been the source of error to all who cited it as an authority. The applicant offered for registration 3 so-called trademarks. The first reads thus: R.W. English S.X. Brooms, Buffalo, N.Y. Order English S.X. Brooms. The two others are precisely the same, except that in one the character XX and in the other 30 are substituted for the X in the first. X was alleged to be the distinguishing feature. The applicant set forth as follows: heretofore I have been in the habit of using X to distinguish my brooms, using X for one quality, 20' for another quality, and 30' for still another quality, by printing, stamping, or affixing the same to the brooms in any convenient manner. The examiner rejected the applications. He said, the label filed has no new or peculiar characteristic to make it a lawful trademark. The letters used in printing it are of the ordinary kind, set up in a common way, and the letter X, used to express quality, is commonly used for this purpose by all liquor dealers, particularly for marking the qualities of ale. A late commissioner, in his decision overruling the officer below, said, the question, with reference to trademarks, is not whether the particular mark is new in its application to goods of all kinds, but whether it is new in the special application proposed for it. In the case of this species of property, a W's is permissible. The fact that a mark has been used for a bottle is no bar to its use by another for a broom, or by another for dry goods, or by another for an agricultural implement. or for hardware. One man may choose to call his knives, XL knives, and another his baskets, XL baskets. The use of this mark in no way implies that the baskets were made by the manufacturer of the knives, or vice versa. He therefore held that the letter X, when employed to denote a particular article of manufacture, being in no way descriptive, but a new arbitrary character, which may, when adopted and used, indicate the origin and ownership of the goods to which it is applied, may well constitute a proper trademark. He further held that 20 and 30 are as distinguishable from X as the latter is from Y or Z, or any other character. He also said that the use of the letter X is not an ordinary mode of indicating quality. The three cases were thereupon registered. Section 163. The general legal proposition, that two men may adopt the same symbol, if to be used upon different classes of goods, requires no comment. The question is this: did the letter X, under the circumstances presented, constitute a lawful trademark? If used merely to indicate quality, it clearly did not. That point is too well settled to be disputed. What idea is conveyed by the use of the letter X? Has it not from its long association come to be well recognized as a mere indication of quality, as much as the numerals 1, 2, 3? That is a pure question of fact. It was a bare assumption to hold the contrary in the absence of the slightest evidence. How could any tribunal take judicial note of the fact that it was otherwise? The case before the office was one where the applicant positively alleged that he used the letter, single, doubled, or trebled, as an indication of the respective qualities of his brooms. The allegation of the specification was conclusive. The fact was there enunciated. The commissioner travelled out of the record. His opinion, then, as to the doctrine that the letter X does not generally indicate quality, is but an obiter dictum, a wayside opinion, not binding in other cases. Section 164. There must be some word, or sign, or device, other than the generic name, and words descriptive of quality. Under this rule, the proposed trademark beeswax oil was refused registration. The name oil is generic. The word beeswax is doubtless intended to be more or less descriptive of the quality or nature of the oil. The words, razor steel, as applied to the blades of knives, shears, and other cutlery, were rejected. The word razor is purely descriptive, and the word steel a generic name, and being limited to neither person nor place, so as to indicate either origin or ownership, they cannot be regarded as constituting a legal trademark. Candurango ointment, c. 0, is not a legitimate trademark, ointment being a generic term, and Candurango the name of a plant extensively known, and the initials C.O. immaterial, and not likely to be noticed. The applicant in another case sought to register the word invisible, to be applied to packages of powder intended for beautifying the complexion. Mr. Commissioner Leggett said, that the word, invisible might be used as a lawful trademark, I have no doubt, but when used to indicate the character of the thing to which it is attached, it becomes descriptive, and cannot be monopolized. Such, without doubt, is the application of the word invisible in this case. The intention of the applicant in the use of the word evidently is to indicate that the powder, when applied to the skin, is imperceptible or invisible, hence the word is used with its ordinary signification, as in the description of shades of colors, and when so used is, by the rulings of the courts, excluded from the list of devices that may become legitimate trademarks. Section 165. The courts of France have made a number of decisions upon this point. In the Court of Colmar, in 1857, Rian v. Bernheim, it was held, the denomination toy isle ménage is not a special denomination which can become the exclusive property of a manufacturer. The term had by long use become common to commerce. The Tribunal of Commerce of the Seine, in 1858, Thibige v. Gipontet ALS, for the same reason rejected the words benzine parfumé. The Tribunal Sif of the Seine, in 1861, More Prives v. Bouchet ALS, had this case. The plaintiff's mint drops were marked in relief, Peppermint, London. The defendant, who had imitated the mark upon the same class of goods, for defense argued that the words were but an indication of the nature of the preparation, and therefore could not become private property. But the court held that the union of the two words, placed in relief, and with characteristics determined and distinct, were a particular sign to indicate to the public that they belonged to the inventor thereof. This in effect decided that, by the manner of use, these words had acquired an individuality sufficient for the destined purpose. The same parties appeared before the Court of Paris, in 1864, on appeal. Held, peppermint is but the English appellation, but by long use in France it has become common to commerce. The simple indication of this product, in one language or the other, cannot be protected. The court plainly intimated that a particular form or disposition of letters might make it valid as a personal sign. This would virtually make it a distinctive sign of origin. Section 166. When a chemical product takes naturally, in certain given conditions, the form of a known object, its denomination cannot become private property. The case of Barnett v. Kubler, in the Court of Paris, in 1866, illustrates this doctrine. Everybody knows, at least by name, the scientific toy called the Serpent of Pharaoh. It is sold under the form of a little cone covered with tin foil. When set on fire, it acquires an extraordinary development, and, with the movements, takes the form, length, and color of a real serpent. The demandant described its mode of manufacture. He employed the sulfocyanide of mercury, obtained by the action of nitrate of mercury on the sulfur cyanide of potassium. The containing box had upon it a notice of poison. The demandant had patented the toy, but the patent had been invalidated, as being for a worthless invention. As inventor, he had given to it the name of Serpent of Pharaoh. It was sometimes called the artificial serpent and the eggs of Pharaoh. The defendant sold a similar article under the name of magic serpent. An action was brought for infringement of the alleged trademark. Among other things, the defense set up that the toy was poisonous, and consequently contrary to law, and to the public security. But on that point the court ruled, that as the attention of the Council of Health had several times been called to the article, and nothing had been done to prohibit the sale of it, the conclusion was warranted that it presented no serious danger, and therefore was not unlawful. The next question was this: do the words Serpent of Pharaoh, as used, constitute a trademark? If yea, is the use by the defendant of the term magic serpent for a similar article an infringement upon that mark, as a colorable imitation? In support of the claim, the counsel, M. Patel, eminent for learning in the law of the subject, argued thus: the words eggs and serpent, employed to designate the thing which was neither eggs nor a serpent, but which, upon combustion, gave a resemblance more or less removed, are clearly fancy names, belonging to him who first makes use of them. In support of that theory, he cited the decisions of the Court of Paris and the Court of Cassation in the instance of pearls of ether, a title given to ether pills, which, as pharmaceutical products, belong to the public in general, and by their form and silvery envelope resemble pearls, and which words notwithstanding were held to be a trademark. Held, the term serpent does not constitute a trademark, it being natural and necessary to describe the article. The use of the word serpent by the defendant is not piracy. So the words night blooming cereus were held to be invalid as a mark, being the proper descriptive appellation of an article. The same rule defeated the adopter of the words desiccated codfish. Section 167. Since the foregoing got into type, the following case arose. A claim was made to the exclusive use of the words, cable twist tobacco, as a trademark for plug chewing tobacco. The applicants set forth that they had used said words for that purpose for about 2 years last past, i.e., from about the year 1870. The examiner rejected the application, on the ground that the words cable twist are purely descriptive of the goods to which they are attached. An interlocutory appeal was thereupon taken to the commissioner, in person, the main question being this: are those words the proper denomination of the article of manufacture? Section 168. Upon the argument, the counsel for the applicants produced a piece of the manufactured tobacco, and a drawing filed in the office in an application for a patent for their mechanical process of coiling the tobacco into the exact representation of an ocean telegraph cable, which thing, said the counsel, had first suggested the name. The new article of manufacture consists of a strand or rope of tobacco coiled spirally about a filler or core, and then pressed flat, or into any other desired form. The object of the invention is alleged by the specification to be to provide a plug tobacco in such shape, and of such arrangement, that the portion of it desired for use may be severed from it without uncoiling the remainder of the plug. After the coil is wound round the core, the bunch is placed in a mold, and reduced by hydraulic, or other, pressure to the shape of a flat plug. After this operation, a number of the plugs are placed in a tobacco caddy and pressed, the process of filling and pressing being repeated until the caddy is full. Section 169. It was conceded by the Council that any article's appropriate name, which has become a part of our common language, cannot be registered or recognized as a valid trademark, but it was strenuously denied that the words cable twist, as here used, could be brought within the rule. It was admitted that the words cable, twist, and tobacco, are the common property of the public, and the words cable twist, when combined, are also in general use, designating as they do a kind or class of tobacco, but the Council denied that such is the case in respect to the combination of the three words. Cable twist tobacco, it was contended, is a combination quite unknown to the public, except as the mark or symbol of a particular firm, the kind or class being twist, and the word cable being purely fanciful. The objection that the word cable is descriptive seemed to the Council to be untenable. The case was instanced of the famous smoking tobacco put up in green drums, and sealed with green wax, and having applied to it as a trademark the words green seal tobacco. Section 170. The examiner replied that the color of the drum and wax were mere marks or symbols of the merchandise, and as green paint or green wax cannot enter into the composition of tobacco, the color in such case cannot be deemed to be descriptive, any more than the color of wax on bottles, as illustrated in the French case of Badoit v. André, in the Court of Appeal of Lyon, in 1851. In that case, the parties both sold the water of Saint Garmier, though each drew from a different spring. They had adopted very dissimilar exterior signs to distinguish their bottles. Badoit used a green seal, bearing the inscription Mineral Water of Saint Garmier, Badoit Spring, and C. André, who had quite another kind of designation, in 1850, without abandoning his peculiar mode of indication, all at once adopted the green wax. The court held that the color of the wax, as thus employed to seal bottles of mineral water, constituted a trademark, and a sign of goodwill worthy of protection as the exclusive property of the plaintiff, and the defendant was accordingly enjoined from using for that purpose wax of the same color as that used by the plaintiff. Section 171. The Council further said, inter alia, that one might make candy, and color it to resemble a cable, and mold it into an exact representation of the applicant's tobacco, and use the words cable twist candy, and enjoy the exclusive right of the employment thereof for that purpose. The words would necessarily be descriptive. The public would come to know the candy as cable twist candy. The words might in time become the appropriate name of the article, and still the sole right to use the designation would remain in him who first applied it to candy. That is, that any person might apply the term cable twist to any goods, as a fancy name, and hold the same as a valid trademark, although the words might possibly be to some extent descriptive. Section 172. The case of Brown's Jamaica Ginger was cited as an illustration of the idea, and the remarks of Paxson, J., in the suit of the Dixon Crucible Company v. Guggenheim, were relied on as confirming the same. We turn to that case, and ascertain that what the judge said was this: our late fellow townsman, Frederick Brown, for many years before his death, prepared and sold a valuable article of Jamaica ginger. It was known as his article, and protected by his trademark. His son continues its manufacture. No one doubts his right to do so, or that equity would restrain an unlawful interference with his rights. The article would be protected by his trademark, says the judge. He did not say what that trademark was. Was it the mere appellation of Brown's Jamaica ginger, as the counsel contended? It assuredly was not. The Patent Office has answered that question. Upon the application of the very gentleman mentioned, as successor in business, The point was passed upon. Mr. Brown applied for the registration of a facsimile of the signature of his father and predecessor, as his lawful trademark for Jamaica ginger, and his claim was allowed. The name of the commodity does not constitute any essential part of that mark. Section 173. The counsel then said, that a fine-cut chewing tobacco of a bright yellow color, might be properly marked yellow moss chewing tobacco. Conceded, and for this reason, the first term is purely fanciful. Yellow moss does not enter into the composition of chewing tobacco. Section 174. The counsel then suggested that the words snowflake starch would be a valid trademark, although applied to starch manufactured to resemble snow flakes. Denied, unless the claimant of a right to the exclusive use of the words have also the exclusive right, by virtue of a patent, to make starch of the appearance of snowflakes, which is hardly a supposable case. If a person has a patent to make an article of any peculiar conformation, he may undoubtedly give it its proper descriptive name, and he would be protected therein, unless that name be generic, or broad enough to describe articles which others have an equal right to make and vend. Cable twist tobacco, the counsel contended, although used as a brand, is not yet properly a name, and cannot become a name until the diligence of the applicants make it such. It may doubtless pass into common use, and in time come to be a quasi-generic term, but at present has nothing more than a fanciful significance. Perhaps every valuable word, trademark in existence is more or less generic, and each may in the course of time take its appropriate place as a common noun, and be entered as such in the lexicons of future generations. Section 175. The Commissioner of Patents affirmed the decision of the examiner, and held that the words cable twist tobacco are descriptive, notwithstanding the transformation of the ropes or cables into rectangular blocks. He said that the words clearly indicate an article of chewing tobacco manufactured in a peculiar manner, by twisting and coiling the plant into the form of a cable, just as hemp and other vegetables are manipulated. A cable continues to be a cable even if pressed out of shape. The idea is conveyed that the article offered for sale is tobacco, manufactured by the twisting or coiling process. No one would attach any other meaning to the term cable twist, as used in connection with tobacco. It describes an article of merchandise that all manufacturers of tobacco have a right to make and sell. The applicants cannot have the monopoly of all tobacco manufactured in the form of a cable. Although they have made an application for a patent for a peculiar kind of cable-shaped tobacco pressed flat, they may have the sole right to make it in one way, and somebody else may have quite as good a right to make it in another way. If others have, or may acquire, a right to manufacture any other kind of cable twist tobacco, they have the legal right to call the thing by its right name. But if the claim of these applicants were allowed, that would not be so. They would to that extent control the use of words in common use. Section 176. The applicants by their counsel made a motion before the examiner for a rehearing. Since the judgment of affirmance by the commissioner, they had obtained the grant of a patent for 17 years for their peculiar mode of manufacturing tobacco, as hereinbefore described, and it was argued that that fact put a new phase upon the matter, inasmuch as thereby they now had the sole right to make and vend chewing tobacco made first in the form of a cable, and then pressed into flat plugs. The counsel urged the necessity of the recognition of the name as a trademark, as the applicants, stated to be the most extensive tobacco manufacturers in the world, made a profit of $20,000 a year by the sale of cable twist tobacco, and required the sole use of the name as a protection to their legal rights. Admitting that there is propriety in drawing a line of demarcation with nice discrimination in a case of mere description, it was said by the counsel that such an objection was obviated by the grant of a patent. Section 177. The examiner, in reply, referred to a patent more than 3 years old, for another kind of improvement in the manufacture of chewing tobacco. In that case, as is seen by the specification, the tobacco is spun or twisted together into one continuous break or rope, and then coiled or pressed down into the keg, box, or other package, in which it is to be packed for market. The benefits claimed by the earlier patentees are the same as now set forth, the convenience afforded to the consumer in breaking off only so much of the weed as he may need at the moment, The article manufactured under that patent is one kind of cable twist tobacco. The public have a right to apply to it the descriptive name. The council insisted that the term was not understood by the trade to be descriptive, and asked leave to present evidence to that effect. The reply of the examiner was, that the obvious and legitimate meaning of words in common use cannot be explained away by any possible amount of testimony. The office must judge for itself. No cause for a rehearing has been shown. Case dismissed. Section 178. The name of a man may lose the idea of personality, and become a mere indication of quality. This point was decided by the Court of Cassation, the Supreme Judicial Tribunal of France, in the case of Stubbs v. Astier et al. In 1865. The plaintiff, a manufacturer in England, brought suit to restrain the use of his name upon articles of merchandise made and sold in France. Under the treaty made in 1860 between the two countries, he had a standing in court, his claim having been refused in the court below, on the ground that the name had attained a generic significance before the Treaty of Reciprocity had taken effect. The case was appealed to this, the court of last resort. It was contended on one side that the name of Stubbs had lost its primary use, which was to indicate certain articles of hardware and cutlery as being his manufacture, and that by long use it had acquired a new attribute, and that to hold otherwise would be to take away rights that had become vested in the French people. On the other side, it was strenuously contended that a man's name is his distinct property, and remains a property sanctioned by the law of nations, and although the mark attached to it had fallen into the public domain from any cause, the name did not cease to be the exclusive property of him who bore it. The court said that, for more than 60 years, the French manufacturers had made a certain kind of saws and files, on which they placed the mark Stubbs, with the initials P.S. inverted. That said mark had become, in France, the indication of a product of superior quality, that it was not the indication of the origin of the manufacture, but was rather the designation of the nature and the quality of the product, of which it was the denomination, so that a purchaser could not be deceived into the belief that to him was presented an English product of the manufactory of Peter Stubbs, that the files seized at Astier and Le Chevalier Place bear, independent of this mark, Stubbs, P.S., inverted, the initials G.S., indicating the real maker, that the files and saws seized at Reynauds were wrapped in labels which made known the real place of manufacture, and that those divers circumstances manifested good faith and the absence of wilful injury. The same court, in 1864, in Spencer and Sons v. Payne, held the same doctrine. In that case the English manufacturer's name had for 50 years been employed in France to indicate not the origin, but the nature of certain products. As foreigners, the parties in both cases had no privileges in the courts of France until the Treaty of 1860, and that although the English courts were open to alien and subject alike, by the time they could be heard in the assertion of natural rights, their names had been turned to another than the original purpose, so far, at least, as the territory of France was concerned. The soundness of these decisions is questioned by distinguished jurists, among them M. Patel. Section 179. In the case of Bornhonnet F. Basil, successors of La Maison Denox, v. Tisserand et al., in the Court of Cassation, in 1869, we have an instance in point. It was held that the successor of merchant cannot prevent other merchants from using the name of his predecessor to designate the products of their fabrication, when the name has long been used as the designation of a certain kind of products manufactured by the generality of the trade, and which has thus become public property as a qualifying term, a mere adjective. It is especially so in the employment of the name of Denox, to designate a certain kind of Brock shawls. Section 180. The case of Singleton v. Bolton, before Lord Mansfield, in 1783. Is an illustration of the doctrine that a man's name may become a mere qualifying word. The plaintiff's father sold a medicine called Dr. Johnson's Yellow Ointment. The plaintiff, after his father's death, continued to sell the medicine, marked in the same way. The defendant also sold the medicine, with the same mark, and for that alleged injury an action was brought. The plaintiff was non-suited. A rule having been obtained for a new trial, Lord Mansfield said that if the defendant had sold a medicine of his own under the plaintiff's name or mark, that would be a fraud, for which an action would lie. But here, both the plaintiff and defendant use the name of the original inventor, and no evidence was given of the defendant having sold it as if prepared by the plaintiff. The only other ground on which the action could be maintained was that of property in the plaintiff, which was not pretended, there being no patent. Section 181. We have familiar instances of a person's name becoming a mere indication of a certain article or class of goods. Wellington, Brougham, Stanhope, Blücher, and Menton are personal names that have given us the Wellington boots, the Brougham or the Stanhope carriage, the Blücher boots, and the Manton fowling piece. But it is not understood upon what principle a person's mercantile name can be wrested from him by the mere lapse of time. In the Stubbs and Spencer cases, the fact was apparent that in England those names were regarded as marks of origin and warranty. If good for that purpose in one country, they were equally efficacious for the same purpose in any other. The rights of their owners might be in abeyance, but they could not be lost. Section 182. Geographical name. There are decisions which are supposed to justify the adoption of a mere geographical name as a trademark. One of these is Newman v. Alvord. The word Akron was the subject of the controversy. The plaintiffs were manufacturers of cement or water lime, at the village of Akron, in the county of Erie, N.Y. The defendants were engaged in the same line of business at Syracuse, N.Y. The court, on appeal, held that this name, although geographical, designated the origin of the article made and dealt in by the plaintiffs, as well as the place of manufacture, and was appropriately used in these respects, for the material used by the plaintiffs was obtained and manufactured into water lime cement at the village having that name. The doctrine that the name of a locality may be exclusively appropriated was distinctly enunciated, but it was also held that what may be claimed or used alike by all in the said place cannot be exclusively appropriated to advance the interests of one. Daniels, J., delivered the opinion of the general term. After reviewing various authorities bearing upon the question at issue, he said, in the present case, the term selected to identify and distinguish the plaintiff's manufacture from those of a similar character placed upon the market by others, had never been previously used for any such purpose. The use of it imposed a new attribute or office upon the word, which specially adapted it to indicate and distinguish the origin and place of the plaintiff's manufacture, and it in no way entrenched upon the previous use or purpose to which the term had been in any way devoted by others. The term was made to bear and perform an entirely new duty or office, which could result in no embarrassment, prejudice, or injury to any other person whatsoever. And from the continued use made of it in that respect, it has become an important and valuable element in promoting and securing the prosperity of the plaintiff's business, and as such the defendants should be restrained from making a similar use of it. While, for the purposes of that controversy, the court upheld the doctrine that the name of a place does indicate origin, we must not be misled by the broad language of the court. The plaintiffs came into court with clean hands, asking redress for an attempted fraud by the misuse of the word Akron. What did that case decide? It virtually decided that that word did not, as presented, possess all the ingredients of a lawful trademark, for it lacked exclusiveness of the right of user. Mr. Justice Strong, of the Supreme Court of the United States, in the case in that court, before cited, said that the decision in the Akron case substantially concedes that the plaintiffs by their prior appropriation of the name of the town in connection with the words cement and lime, acquired no exclusive right to its use as against anyone who could use it with truth. All the inhabitants of the village of Akron had the same right to brand or label their goods with the name as had the plaintiffs. Therefore it was not purely a trademark in its broadest sense. As against a wrongdoer who had attempted by fraudulent means to divert custom from its legitimate channel, it was good. The important word is the name of the place where the cement is made. The article manufactured is taken from the earth. It is a bed or quarry of lime. There is no special art or skill in making it into cement. The cement taken from different beds differs greatly in value, as in quality. The reputation of the plaintiff's cement arises from the reputation of the bed or quarry from which it is made, the Akron bed. They speak the truth in using the name. They tell the public by their bills, this is Akron lime. It is made from the Akron beds or quarries. The public have used it for years, and appreciate its qualities. The defendants, at a distance of 150 miles, change the name of their quarry, and incorporate the most significant word used by the plaintiffs for many years, and then prepare bills with this word prominent in them, and bring their article into markets in competition with the plaintiffs. It was not necessary for the purposes of the particular case under discussion for the court to decide in so many words that the word akron was a technical trademark. The concluding sentence of the decision is sufficient to determine what was really decided. Held, the plaintiff's right to restrain the defendants from making use of the word akron as their trademark is reasonably plain, and the judgment awarding the injunction should therefore be affirmed. Section 183. The Brooklyn White Lead Company v. Marjorie, before the general term of the Supreme Court of New York, in 1857, said that it is to protect a man's right of selling his own that the law of trademarks has been introduced. It must include the right to sell to all, to the incautious as well as to the cautious. Any false name that is assumed in imitation of a prior true name is in violation of this right, and the use of it should be restrained by injunction. The plaintiffs had been engaged for more than 20 years in the manufacture of white lead, and had habitually marked their kegs with their name, adding the words, "Premium Lead, Warranted Pure." Both parties manufactured in the city of Brooklyn. As they both dealt in the same article, they had the same right to describe it as Brooklyn White Lead, and it was shown that many other companies had used the same designation. The defendant changed his mark, and assumed one to which he had no title, in imitation of the plaintiffs, with only a colorable difference, that of Brooklyn White Lead and Zinc Company. He had no such company, and that part of his new title seems to have been adopted to imitate the plaintiffs, and to make his paint pass as theirs. This was a fraud. Held, the defendant should be enjoined from the use of the word company, or CO. He may continue to use the title, Brooklyn White Lead and Zinc, only omitting the word company. Section 184. In McAndrew v. Bassett, in 1863, the Lord Chancellor said, "I am told that this word Anatolia, being a general expression, being in point of fact the geographical designation of a whole country, is a word common to all, and that in it, therefore, there can be no property." That is nothing in the world more than a repetition of the fallacy which I have frequently had occasion to expose. Property in the word for all purposes cannot exist, but property in that word, as applied by way of stamp upon a stick of licorice, does exist the moment the licorice goes into the market so stamped, and obtains acceptance and reputation in the market, whereby the stamp gets currency as an indication of superior quality, or of some other circumstances, that render the article so stamped acceptable to the public. This is a recognition of the doctrine that a geographical name may cease to be merely such, and acquire a new function, as an arbitrary symbol. If it were not so, any word that might be found to be composed of the same letters in the same order, as the name of any country in the world, might be rejected as a trademark, and that although the adopter of the word had never heard of the country bearing the name of his chosen word. The licorice was stamped with the name Anatolia by way of contradistinction from other kinds of licorice. It was not intended as a mere representation that the article was Anatolia licorice. It acquired reputation. The defendant knew that, or he would not have simulated it. It was upon the same principle that, in 1862, the Tribunal Cif. of the Seine, Favor v. Duguer et al., held that Mount Carmel, although geographical, was good as a fancy name. The case of Wotherspoon v. Curry, in v. C. Malines Court in England, in 1870, is sometimes cited as an authority upon the same point. It appeared on a motion for an injunction that, for several years before 1847, Messrs. Fulton and Co., of Glenfield, near Paisley, manufactured powdered starch, principally from East India sago, called Glenfield Patent Double Refined Powder Starch, commonly known as Glenfield starch. In January, 1847, the plaintiff, William Wotherspoon, purchased of Messrs. Fulton and Company their business and works at Glenfield, and the exclusive right of manufacturing starch and selling it under the name of Glenfield Patent Starch. The plaintiff afterward removed his manufactory to Maxwellton, near Paisley, where he made and sold his starch. The defendant, Curry, rented from Messrs. Fulton and Company a small building attached to their dyeing works at Glenfield, and manufactured starch, which was sold in packets of a size and appearance similar to the plaintiff's, and labeled the Royal Double Refined Patent Powder Starch, manufactured by Curry & Co., Glenfield. The plaintiff's case was that the defendant had taken the small building at Glenfield for the express purpose of inducing people to believe that his starch was the article made by the plaintiff. For the defendant, it was urged that, as he was an actual resident at Glenfield, and his manufactory was there, he had as much right to put his address upon the labels of the starch as had the plaintiff, who did not actually reside at Glenfield. An injunction was granted, the Vice-Chancellor remarking that he had never known a case in which a defendant had been guilty of more reprehensible conduct. Section 185. This case came up on appeal before Lord Justice James, on a motion by the defendant to dissolve the injunction. Lord Justice James said, "I am of opinion that the injunction in this case cannot be sustained. The word Glenfield is not a fancy name, like their Victoria or the Albert or the Excelsior, and various names of that kind, which were fancy names, actually constituting a trademark in themselves. But Glenfield, although it is not a place as big as London, Glasgow, or Paisley, and is not even a post town, or a market town, or village, is a place which has an actual existence as the site of some manufactory, is yet a place containing some few houses, and is a place at which the plaintiff's starch was manufactured." The defendant, no doubt moved by the great reputation which the plaintiff's Glenfield starch had acquired, was minded to establish works at Glenfield. That was what anyone might do. Although the works of the plaintiff had been removed from Glenfield, Glenfield was not, as it seems to me, tabooed to all the world as a place or site for the manufacture of starch. The act of the defendant was legitimate. "There are two classes of buyers," said the court. "One is the class who can read, and the other is the class who cannot read. They who can read cannot be misled, if the language differs. To the persons who cannot read, the packets are dissimilar, and could not deceive." Section 186. In Colliday v. Baird, 1860, the complainant alleged that he was the manufacturer of a certain style of goods known in the market as Aramingo check. That, in 1854, he had devised a certain trademark, or name, to wit, the words Aramingo Mills, which mark became identified with the goods manufactured by him, although his name did not appear upon the label as manufacturer, and that the defendant, intending to deprive him of the exclusive use and benefit of his trademark, cunningly devised a label upon which the words Aramingo Mills appeared, and thus by a colorable artifice succeeded in defrauding him of a portion of his well-earned reputation and profit. It appeared that both parties manufactured their checks at the same establishment, the defendant being in fact the lessor of the complainant. The defendant asserted his perfect right to use the words. The labels were of different size and color, so that the most ignorant could not fail to detect the differences in their general appearance, and the court said that there was not a colorable imitation, device, or artifice. The court refused a special injunction, leaving the complainant to maintain his title as best he could in an action at law. Section 187. In the Tribunal Sif. of Avera, in 1859, Levy-Gruux et al. v. Leon Lecomte came up this matter. Both parties imported the same kind of merchandise. The plaintiff's mark was valide or in a semicircle, and underneath in a straight line the words Levy-Gruux et Postel. That of the defendants was valide or and the initials, L, and S, of their firm. It was shown that valide or was the name of a place in South America. The defendants truthfully employed it to indicate the origin of their products. Held, no infringement. In the Court of Paris, in 1859, Bisson, Aragon v. Aragon, the plaintiff's mark was Massey, their place of manufacture. Held, that defendant had a perfect right to use the words Pres Massey, his manufactory being really near Massey, and that although others had previously adopted the word Massey as a distinctive symbol. Section 188. Newman v. Alvord resembles the last case. There it appeared that the complainants had been manufacturers of cement or water lime at Akron for about 13 years, and that they had always designated and sold their products as Akron Cement, and Akron Water Lime. The defendants commenced a similar business 12 years later, at a place far distant from Akron, and called their product Onondago cement or water lime. It was a fraud upon the complainants and upon the public. Consequently, an injunction was granted. The court substantially conceded that the complainants had not acquired an exclusive right to the name as against one who could use it with truth, and that, as no one had the exclusive right to the name, it was not a trademark. Section 189. The question of the appropriation of the name of a region to the exclusion of others who produce, or who sell, a similar product of the same region, may be considered as definitively settled. The case of the President, F.C., of the Delaware and Hudson Canal Company v. Clark, already referred to, was well presented and argued in the Supreme Court of the United States. In 1872, the leading question was whether the complainants had an exclusive right to the use of the words Lackawanna Coal as a distinctive name or trademark for the coal mined and sold by them. The word Lackawanna was not devised by the complainants. They found it a settled and known appellative of the district in which their coal deposits, and those of others, were situated. The defendant invaded no right in employing the name, for he made no false representation. All the coal taken from that region is known in trade, and rated in public statistics, as Lackawanna coal. Section 190. The case of Desire Michel F. Company v. Acadefco, in the Court of Cassation, the Supreme Court of France, in 1863, bears a striking family likeness to the Lackawanna case. Many years before, in the commune of Papin, the plaintiffs had established a manufactory of cement, to which they gave the name La Valentine. Their works were situated near a brook bearing this name, which it takes from the hamlet La Valentine, situated in the commune of Saint-Savornin, contiguous to that of Papin. The defendants had recently constructed cement works in the commune of Saint-Savornin, not far from the hamlet of La Valentine. Both parties took their limestone from the same quarry. The defendants advertised their product under the name of cement of La Valentine. Was La Valentine a lawful trademark? If yea, did the defendants infringe it by the use of the words La Valentine? The court said that jurisprudence sanctions the doctrine that natural products, or even manufactures in the same place, may lawfully all be designated by the name of the locality where produced, unless encroaching on the name of a manufacturer, or his trademark. The name of La Valentine cement is actually known to commerce as the proper designation of an article produced within certain boundaries, embracing the works of both parties, for they both use the same quarry. The name, La Valentine cement, corresponds to the designation of Vassy, Roquefort, Lanurthe, and C. cement. Therefore the plaintiffs cannot pretend that the name is restricted to themselves. The designation of locality cannot serve as the foundation of an exclusive right. Apostrophe. Section 191. The Congress Spring case is not an exception to the general rule, for in that it was shown that the plaintiff had the sole title to the place which was the source of the medicinal waters to which the name or mark was affixed. The same name could not be used with truth by other dealers in mineral waters. The Brooklyn White Lead case is in point. Then it was decided that all manufacturers in Brooklyn could properly use the name. The defendant was enjoined against the use of the word company or co, which was a fraudulent part imitation of the plaintiff's label, but was permitted to use the name of his place of manufacture. Section 192. When is a name merely geographical? When we glance at the case of Armistead v. Blackwell in the chapter on interferences, and see how judicial officers disagreed as to the meaning of the word Durham, we hesitate before making answer. A word may be considered to be geographical or not, according to the circumstances of the case. If merely geographical, we know that it cannot be a lawful trademark. It behooves us, therefore, to scan closely. Section 193. This question frequently comes up in the Patent Office, and the rule for answering it is well settled. If the word is not intended to be geographical, and is not taken to be such by the public, it is not such. It will have become, as an arbitrary symbol, as good an index as could be any other symbol. Thus the word Maryland, although intended for a mark for merchandise manufactured in Maryland, is free from objection. The change in the spelling, and slight difference of sound, are sufficient to distinguish it from the usual and proper designation of the original Terra Marie, named for Henriette Marie, the Queen of Charles I. of England. And no reasonable person would think that the use of the name Monticello, for whiskey, was intended to intimate that the article was distilled or sold at the home of the venerated sage of Monticello, or that the term Kentucky Pioneer necessarily meant that it was made in Kentucky by the pioneer Daniel Boone, or that Bay State meant to imply Massachusetts. At first it was thought that the words Ville Montagny were open to the objection of being a mere geographical designation, just as Old Mountain might be if the French were translated, but, upon reflection, it was concluded that the words could not, without straining their meaning, be taken to import that the green paint to which it was intended they should be affixed was manufactured at a place of that name. So Wisconsin wood chopper could not mislead any reflecting mind into supposing that the axe bearing that mark was peculiar to, or made in any particular state. The word Seattle is the name of the county, as Cedarville is the name of the town, where the applicants make fire brick, tiles, and wherefore the examiner rejected the application, as a geographical term, which anyone in the county had a right to use. The commissioner took another view of the matter, regarding it as an arbitrary symbol which no one else would be likely to impress on brick. Past. It is not understood upon what principle this decision in the Seato case could possibly be sustained. It may be that it never shall be brought in controversy in a judicial proceeding. If others have an equal right to use the name upon the same kind of wares, then it cannot be a trademark, for the essential element of exclusive right is lacking. We can understand how, if one not in a place of that name should fraudulently usurp the word as a mark, a court of equity would be called on to enjoin the wrongdoer, as in the Akron case, as an ordinary case of fraud, not for violation of a trademark. Section 194. As an illustrative case we will take the application for the word Angostura to be used in combination with bitters. The examiner answered the claim. Thus, the article called Angostura bitters is well known as such, to the commercial public at least. A tincture of Angostura bitters is officinal in the pharmacopoeia of some European countries. Year's Dictionary of Arts, and c. mentions the article among other bitter substances used in art and medicine, as quasar, wormwood, orange, gentian, tansy, coffee, and c. He also stated that he was credibly informed by experts, that a favorite drink called a cocktail is composed in part of said bitters. The principal point was whether the word Angostura was not a geographical name, and it was held not to be, for the reason that the word Angostura had been first used by Dr. Seagut, under whom the applicant claimed it had become a fancy name, and as the claimant proved his claim to the exclusive use of it, as the denomination of an article of which he was sole vendor, it was admitted to registration.